Federal Rule of Civil Procedure 11 requires any written factual assertions that an attorney submits to the court to have evidentiary support. Attorneys who violate the rule are subject to sanctions. In Patsy's brand versus I.O.B. Realty, the defendants' lawyers argued that good faith reliance on their clients' falsehoods shielded them from liability. I.O.B. Realty and its principal, Frank Brija, owned Patsy's Pizzeria and sold jars of tomato sauce under the name Patsy's. Patsy's brand sued I.O.B. and Brija for trademark infringement in New York District Court. Patsy's brand requested a preliminary injunction, asserting that it had been using the trademark Patsy's for sauce since 1994, and that its use predated I.O.B.'s. In opposing this motion, Brija swore by affidavit that he'd been using the Patsy's name on sauce since 1993. With his affidavit, Brija included a copy of a 1993 printer's invoice for Patsy's labels and a copy of the label he allegedly used in 1993. In its reply submissions, Patsy's brand pointed out that the label contained a barcode that didn't exist until 1998, and that the invoice listed a telephone number with an area code that hadn't existed in 1993. Thereafter, I.O.B.'s counsel disclaimed any reliance on the affidavit and withdrew from the representation. The district court granted the injunction. The law firm of Penny and Edmonds, or P&E, joined the case as counsel for I.O.B. Brija told P&E that he'd accidentally attached a copy of a 1999 label to his affidavit. Brija also said that, unbeknownst to him, the printer had fabricated the 1993 invoice because he couldn't locate the original records. But when P&E contacted the printer's lawyer, they were told that the printer would testify that he hadn't been doing business with I.O.B. in 1993. Patsy's brand moved for summary judgment. In its opposition, I.O.B. relied on another affidavit from Brija to maintain that it didn't intentionally mislead the court or ask anyone to falsify documents. In this affidavit, Brija falsely claimed that the printer had recreated the 1993 invoice on his own and submitted another label allegedly from 1993 that turned out to be a fake. The court granted summary judgment and issued an order for P&E to show cause why it shouldn't be sanctioned for violating Rule 11.